Okay, well, if you were here the other night, you know that this is going to be a less unhinged version of the latest court documents, which is Justin Baldoni and the Wayfarer Party's response to Blake Lively's latest accusations, which came in her oppositions to their motion for summary judgment and motion for judgment on the pleadings. So we'll go over that. I did go through and make some highlights, so I will be able to skim through some stuff, and it won't be as long as the other night. But if you were here with us on Friday night, I had just gotten back to town. These documents just came out. I then had let's see, Elsie, Zach, Donna, Andy, and Omar even popped in for a little bit. It came on, and we went for 4 hours eventually. I was the only one who was there for the whole 4 hours. But, I mean, they were there for a good 2.5 of them. So it was kind of crazy. Lots of people enjoyed that. I got some negative feedback as well, which is to be expected, I think, for the larger audience. But, I always do lots of shorter form content for people that need to have shorter videos or whatever. And I think that every now and then, if I want to do something longer and hang out with friends, that's fine. So most people were supportive, though, and enjoyed that. I mean, sometimes it's nice to, I don't know, just watch other people goof off if you're bored on a Friday night, or like maybe you just wanted to watch and be like, wow, these people are so insane. I feel less bad about myself, which is valid. And also a good reason to watch. So, but every now and then I get these comments. They're like, oh my God, why are you doing it like this? Don't make those voices. Don't make those accents or whatever. I'm like, dude, I'm sitting here like having a good time doing what I do in my free time. This is not my day job. There's like a small amount of people who, I don't know, they just feel super entitled to control the way everyone does things. I'm like, first of all, you're way outnumbered here. Second of all, I don't answer to you. I answer to my boss during my daytime job hours, but that's about it. So, but I did want to come back and focus up a little bit and do a shorter version of reading these documents. So if you couldn't stick around the other night or didn't want to watch it on replay, I don't blame you. It was a long time, but there was implied nudity in there. There were accents. There were wigs. It was a lot. So, but we'll focus on the documents tonight. Like I said, I went through and highlighted. I've read it. I will be stopping to comment quite a bit. So again, if you don't like that, fucking off is free. I don't have a problem with you leaving. I think if I see somebody make negative comments about how much I'm talking on my YouTube channel, they're probably, if I see like on the function where it says show all comments on channel, if you've ever only been negative, I'm probably just going to ignore you and mute you, to be honest. So we're going to go ahead and get into this, and I'm going to do it how I want to. And well, everyone who has a problem with that, like I said, fucking off is free. I even have a wiki how of instructions for you if you really need it, but hopefully you won't. So, okay. Let me pull up this first document. So we'll go over both the motion for summary judgment stuff and the motion for judgment on the pleading stuff. The judgment on the pleading stuff is really short. It's like 15 pages. But the motion for summary judgment for the layperson is a little more interesting. So we'll do that first. Okay. All right. Lively spills lots of ink attempting to conjure up factual disputes, but the material facts are undisputed. Her opposition in 56.1 response, which this, guys, we'll go over this another night on its own because it's very long. So I want to go over that, but not tonight. Confirmed she has launched a massive legal campaign to address minor grievances, all of which were resolved during production of the film without the need for any litigation at all. She recites a litany of supposed harassment, ranging from yelling to defensiveness, to a conversation Lively herself initiated about. And okay, so the redaction here is, it's redacted, but the redaction obviously says circumcision because of the context clues we have below. So, but I'll keep going. To an incident she assured at the time was a non-event, but cannot say any continued after she asked for them to stop. They did stop. Sorry, one second. Let me turn my phone volume off. They did stop, and then the parties worked together to produce a successful film, bringing her not only riches, but an extraordinary set of professional accomplishments she touted to the Producers Guild of America as a rare achievement for a woman. Not satisfied, she now claims discrimination, arguing, among other things, that her bespoke, heavily negotiated contract was violated, even though she never signed it, and that despite her near total control over the production, she was merely an employee. She also claims defendant unfairly resorted to professional PR firms for guidance, even while she and her husband openly badmouthed Baldoni and ginned up a flurry of negative press against him. She alleges a massive smear campaign, but fails to point to a single falsehood and any defendant uttered against her. Lively's claims do not meet the requisite standards. Summary judgment should be granted. And we'll get into the argument here, but I don't know if you guys saw that Shasti pointed out that, there was something about her little bump video that came out, and Blake implied to the New York Times that the Wayfarer parties probably had something to do with it, and that was part of their smear campaign. And then Blake Lively responded saying it was undisputed that they found no evidence or reason to believe that she was influenced by the Wayfarer parties. So that doesn't do a whole lot for her smear campaign claims, especially because that video was a large part of the attention that came to the public, where they were like, we do not like Blake Lively's behavior. So that's, just insane. So I feel bad that she, had to go through that. I feel bad that, it's still being brought up, but I am glad that Blake finally had to admit that she has no evidence after all of discovery that anything came of that baby bump video. Like, it was totally something that Blake did, and it's Blake's fault that she got backlash for that. So, and that is kind of the theme for the entire smear campaign narrative, if you've read these documents. So, all right. Okay. Lively cannot prove any actionable sexual harassment. Let's see. Nothing in Lively's opposition overcomes the clear reality that she alleges low-level behavior, trivial grievances, and petty slights. Redacted yelling. I think that has to say Justin, right? I mean, it's redacted, but the only yelling I remember her alluding to was Justin apparently yelling at Alex Sachs. So, yelling and the other assorted conduct she alleges may be bothersome, but they do not rise to the level of a discriminatory, hostile work environment. Lively apparently recognizes Baldoni's conduct doesn't get her there. It boils down to a comment about, and then here's the context clue I was telling you about. It's redacted, but it says after she raised the topic and before she agreed to work on the movie. Now, this is something that Blake brought up that was blasted in the headlines over the last week or two. I think it was the last week or so since she filed her opposition. Circumcision, him talking about circumcision was a whole thing. They said Blake Lively alleges Justin Baldoni basically randomly talked to her about circumcision, basically said randomly that he was circumcised, which makes no sense. And in this context, you can see that topic happened before she was ever an employee or an independent contractor with Wayfarer or Justin. It happened in the context of her bringing it up. And based on what we know from her response, it happened while Ryan was around. So this was obviously not a sexual come-on. First of all, ew, why would you think it was a sexual come-on? Second, her husband was right there. And then also nannies were present. So, like, people who take care of babies, people who take care of kids, and the husband and the pregnant woman who's about to have her first baby boy and might be concerned about circumcision, what choice to make, brought this topic up. Justin at one point said that he was circumcised, and she turned that into a sexual thing. Now, people have their different opinions on circumcision. I'm not here to comment on that. I think that, I'm not here to comment on religious practices, political ideas, cultural stuff. That's not what I'm doing tonight. So I'm here to read about the legal document. And as far as the legal document goes, I do not see circumcision as a sexual, something that's sexually harassing in nature. If you talk about it, especially if you bring it up at your house before you were ever employed, and it's like a medical procedural, religious thing that you're discussing with a friend, because Justin and Blake, let's remember Justin and Blake, from what we see in the text messages, they were friends. They were friendly. They were very friendly. And that muddied the waters enough for Blake to be able to come back and make these false claims later. But you're talking to a friend about something that's medical and religious and cultural, and you're having your first baby boy and you don't know what to do. And then maybe he says like, oh, my parents had me circumcised and it was fine. Or my parents had me circumcised and I wish they hadn't. I don't know how the conversation went, but it clearly wasn't a conversation where he was just like, well, let's talk about my penis. He wasn't just like sitting in their house and like, I always say all these creepy scenarios that I that I, when I try my best to think about Blake's perspective on things, I think about the creepiest possible scenario, and they all start with, "Hey, girl." So he didn't just stop and say, like, "Hey, girl." There's no wrapper on this lollipop. "Hey, girl." There's no sheath on this sword, like right in front of Ryan Reynolds. I don't think so. So she's about to have her first kid. Oh, not her first kid. Sorry, her first boy. My bad. She has 4 kids. So she's about to have her first boy. And she's having a conversation with her friend, Justin Baldoni, in an environment that is home to her and not him, with her husband there and all their nannies there, multiple nannies who all take care of kids and all are okay with this conversation. She brought it up. And then he said something about being circumcised. Did anyone in the chat get turned on by that? I don't think so. I think maybe we're reaching a little bit, Blake. But of course, this is what dominated the headlines in the last couple weeks. And I said this the other night, but Billy Bush did a really good segment on that. And I don't know, man. If I could do a thing on this case with anybody, it would probably be Billy at this point, because Billy's hilarious. He's got really good takes. He's very logical. I feel like he's not just like, "I hate you, Blake, blah, blah, blah." You know what I mean? He's like very no emotion driving his opinions, but he's very factually based. He's logical. He's also funny at the same time. Like, I feel like he's a good dude. So if you haven't seen Billy's thoughts on this, you should go watch it. I know that Billy was I think he commented a lot on politics before. I'm not a political channel. I don't give a shit about people's politics online. I think whatever. So that's not a commentary on my political opinions, but I know I've seen Elsie on his show and they're really great together. I've seen now Andy on his show. I feel like I've also seen Zach on his show and Donna. I'm not positive though, because it's been a while. So, but he's a funny dude. So yeah. I don't know how to reach out to people though. So because Christina says, "Oh yes, we have to get you on with Billy." I don't know how to do stuff like that. I'm not a professional podcaster. I'm not a professional YouTuber. I don't know how to fucking do that. So I don't want to just how I just said the "hey girl" thing where I say creepy stuff about Blake's allegations. If I emailed Billy Bush and was like, "I want to talk to you," I would feel like, hey boy, you know what I mean? So I don't want to be creepy, but hopefully we can get in touch someday. So, because I know that he's been covering this for a long time, and I have not, unfortunately, been able to connect with him. But yeah, Bleak on Lively. Wow, that's quite a name. She was probably fantasizing about. Oh my, you're probably right. No, I feel like that conversation may have happened because Wayfair, Justin, Jamie, and the Man Enough podcast, they seem very open about these things. But it's not sexual. It's not creepy. It's not harassing. But anyways, moving on. Hey, Billy, how do you feel about wigs? Shut up, Kim. All right. Moving on. Okay. So she raised the topic of circumcision, and then she agreed to work on the movie after that. So there was no problem, and then she decided to make one. Discussions about sex and sexiness while collaborating about how to depict an intimate relationship in sex scenes, and a remark about her weight made Offset to a person uninvolved in the film. Okay, and Don Saladino, the trainer, who alerted her that one of his other clients asked about her weight because he had to lift it with a back injury, like he had to lift her up. That was really unprofessional on the trainer's part. I would never want to have a trainer who disclosed my conversations with anyone else. So if I ever found out that I have a trainer here who works with my friend and we have to do scenes together, I'm not ever going to hire that person now if that person is Don Saladino, because I know that he can't keep his fucking mouth shut. It was unprofessional. It wasn't a HIPAA violation. Personal trainers are not held to the same standards as doctors and nurses. I've worked with all of these types of people, and I know that personal trainers have a lot more leeway. Whether or not they should be held to the same standards, personally, I think they should. If they have clients who know each other, I feel like they should be held to the standard of keeping that stuff private. But he went ahead and disclose to her what he said because of his back injury. And the most important part of that opinion is it's because of his back injury. If he was just some random dude who was like, hey, how much do you think she weighs? How much do you think she weighs because of some creepy, I don't know, weird sex fetish, then it would be a different thing, right? But this guy is unprofessional, and he cannot be trusted with people who work with each other, obviously. So I think that he should face the consequences of that. I don't know what they are, but I hope people will find out as this case continues, assuming it goes to trial, that he cannot be trusted to keep his client's words and problems private. There was no reason for Blake Lively to ever find out that Justin Baldoni asked about her weight, but Don Saladino, the trainer, decided to put himself out there in a situation where he could gossip and be like, totally the richer person in this scenario, get me on your side. Like, that's kind of how I feel about it. It wasn't like some oopsie, you know what I mean? It wasn't an oopsie. Like, he went out of his way to tell her that. And he didn't have to do it. He could have just been like, well, Justin, I feel like, and he didn't even have to ask Blake. He didn't have to disclose what Blake weighed in at. If that's something that he knew as a trainer, he could have said, well, Justin, I can't disclose that information. And they could have moved on. He could have said, well, Justin, I can't tell you exactly what her weight is. I don't know. But looking at her, eyeballing her, I think that it's best for you to be able to lift this amount of weight comfortably. Or I feel like, based on your injuries and what we're working towards, this should be your goal, this amount of, pounds or whatever. There was so many ways for him to answer that question without doing what he did, because he honored Blake's privacy in that moment as if he were bound by HIPAA, and then he didn't honor Justin's. So that was inappropriate, in my opinion. It was a terrible thing to do, Did the trainer get deposed? I don't know if he got deposed, but he wrote a declaration, which of course Blake Lively then had sealed, which the judge will rule on what can stay sealed and what won't fairly soon, and then we'll figure it out from there. But he did write a declaration, so did Blake. And then Blake and Don's declarations, of course, get held from the public. They get sealed. Her deposition transcripts are sealed and held from the public, but the Wayfair parties are not. And so it just goes to show, like, how bad this case is for normal people in America. Like, because if you're the person who's been abused in a situation, if you've actually been harassed or abused, of course you don't want all of your shit put out there for the rest of the world to see. But that is, unfortunately, most women who get abused, where they're like in that situation, they're like, I don't want this to come out, but I don't have the celebrity power to stop it. But Blake Lively does. Blake Lively can say, oh, I don't want people to know this or that, because then they might know that I wasn't totally truthful. Then they might know that what I said was a little bit exaggerated, and she has the power to get the judge or whoever to think twice, where a normal victim wouldn't. And it's fucked up. And then the Wayfair parties who have been accused are just demonstrating that anyone can accuse anyone of whatever, and then based on their claims, can get this stuff publicly released, like your private communications and all this kind of stuff that should be kept private. It's really unfortunate, because it just shows how much you can abuse the system with these claims of sexual harassment, which, if you've read the documents, clearly don't meet the standard for workplace sexual harassment. So yeah, we'll see. Fucking Office Free 99. There's a guy on TikTok who does those skits, and I love that guy, but yeah. Anyways, 1 second. I need to drink some water. All right. I need to get moving on this, so I got to stop talking so much. But anyways. All right. Blake thus now attempts to make Heath the poster boy of sexual harassment based on what? A brief glance in an already awkward situation, after which Lively undisputedly told Heath, that means she did not argue against this fact. She did not dispute this fact. I'm not saying you were trying to cop a look. So she admits that she told him, I knew you weren't trying to cop a look. Heath showing her a video related to his child's birth, shared in the context of producing a film with a prominent childbirth scene. Again, very important. When it is undisputed, Heath showed the same or similar image to Baldoni and there's another person here, which is redacted, who found it wholly inoffensive. And this is where I find things that are redacted to be somewhat appropriate, because, like, if you are somebody in the industry and you don't want to be caught between these people and you didn't really do anything wrong, you were just sitting there doing your job, or you didn't really witness anything relevant, if there was somebody that they showed that to who didn't witness any of the relevant behavior, I would support that being redacted and that person being left out of it. So there are proper uses of redactions and there are improper uses of redactions. And I think that there is some space there where, on both sides of it, where I don't necessarily agree. I don't necessarily agree that some things should be redacted. I don't necessarily agree that some things should not be redacted. It makes the system very difficult for people, especially people who can't hire a lawyer. So, all right. It is remarkable that after months of discovery, Lively cannot muster anything more to justify the tremendous legal and judicial resources devoted to this case. All right. Okay. Laura Glass, I wasn't criticizing. I was just teasing about the 4-hour link. No, if you're here right now and I can see your comment, we don't have a problem. Like, some people politely raised the issue of, like, I cannot watch a 4-hour live, which is a totally valid thing, because it was a crazy ass live. But Laura, you're fine. I'm talking about people who were, like, flagrantly offensive and, like, only come here to be like, I hate you. You know what I mean? I'm not talking about you. You're fine. You're fine. Don't worry about it. All right. Okay. It is remarkable that after months of discovery, Lively cannot muster anything more to justify the tremendous legal and judicial resources devoted to this case. And that right there, you can look back to the 107 content creators or social media subpoena, like users who were subpoenaed. And I say users, not content creators, because some of them really were just like social media users responding to stuff with like barely any followers, not monetized on any platform. It was crazy. And she got nothing from that. So, it is even more remarkable because whatever concerns she may have had were fully resolved once she raised them. Even Lively does not meaningfully dispute that the entire second phase of filming, including all intimate scenes involving Lively, occurred without incident. Okay. 1. Lively cannot establish the conduct at issue was aimed at her or anyone else because of gender, a basic prerequisite for a sexual discrimination claim. She concedes the alleged conduct affected women and some men. Okay. The alleged conduct they're talking about largely includes the culture of hugging, where you can see that they hug men on set as well. And Wayfair appears to be a company that actually lives by the phrase, we're a family here at their workplace. So they treated their employees, their employers, etc., like a family. They acted like they were all tight-knit and understood each other and wanted to move forward positively. And, they were hugging and high-fiving and having lots of positivity. And we've seen people complaining about that, which is ridiculous because, like, we see so much and these people are so out of touch. That's why it's ridiculous, because we see so much in 9-to-5 America, which most of us have to live in, myself included, that, they say, we're a family here at XYZ company, and it's clearly not true because people are disposable. People are, they're not treated with the kind of respect and admiration that they should be when they do as much work as they do. They do as much extra work far outside the bounds of their roles that they do. And so, like, these people actually treat their employees like a family. And, like, if you are uncomfortable with that, fine. But you knew who you were working for when you signed on for the project. You knew their values. That's something you talk about in any standard job interview. You knew their values. You knew how they operate and what they expect on a set. And you sign up for that. And then later you're like, oh my God, they were hugging as if they actually think we're a family, which is like what they told me during my job interview. But, like, ew. You know what I mean? Like, fuck off. It's ridiculous. And the fact that we're having to sit here with somebody wasting and so let's be very clear about this. She's wasting the time of our federal government A branch of our federal government is the federal judiciary. She is wasting the time of the federal government that is supposed to serve the people, as evidenced by this trial being moved back 2 months because Judge Lyman has to deal with 2 criminal trials that take precedent. She is wasting the time of the federal government that's meant to protect and serve the people to argue her petty grievances about hugging on set. Do we really think that's the kind of person that we want to uplift and show as an icon for women's safety? I don't think so. Lady got hugged on set, told them to stop, and they said, okay. That's not much of a headline, is it? No. My God. There are so many more important and severe and serious things that have happened, to women who work every day in this country. And Blake Lively, who worked 16 days on the set of It Ends With Us and was exposed to a culture of loving and family environment, is like, oh my God, they hugged people. Oh my God. It's fucking bizarre. All right. Anyways. So, Lively's own evidence further undermines her claims. It confirms Baldoni's stated motivation in privately inquiring about her weight was not to demean her as a woman, but to anticipate his own physical obligations. Lively's trainer's opinion is neither admissible or competent evidence on summary judgment. Nor does Lively dispute that she herself repeatedly raised concerns about... and it's redacted. And I think that probably says something about her weight, because she did express, as we know, concerns about her being like pretty, recently postpartum. It wasn't like right away, I don't think, but pretty recently postpartum. So she may have raised concerns about her weight or her figure or whatever. Personally, I'm not somebody who ever thought Blake Lively looked bad as a person. I think her wardrobe choices were interesting, even for me, but, I don't think she looked bad. But she obviously had insecurities about that. And so she raised those concerns. And so Justin privately asked the trainer that they both used, how much do you think she weighs, or how much does she weigh, so that I can know how much I have to train up to be able to lift without hurting myself again. But yeah. Lively continues to complain that Baldoni once complimented her personal outfit and later the same day referred to her wardrobe as sexy. Lively strains to suggest her costume was revealing, but cannot dispute video footage showing it was, in fact, an oversized fleece onesie. So obviously, it was a huge onesie where you can't see any body parts or anything. You're way more covered than women who are trying to appear sexy would appear. And he said, oh, that looks sexy. And she's like, I'm taking it so seriously. She's like, I'm taking it so seriously. I'm being harassed. You can't even see anything in that. So, nor can she show that this was a gendered attack. Lively notes Baldoni similarly referred to a male actor as, and it's redacted. That could just say pretty or something. I don't fucking know. Or sexy. He could have said a male actor looked sexy in his outfit. I don't know. While Lively herself joked about, and then it's redacted, another male actor to market the film. Okay. Proclaimed that redactions and insisted upon the redactions of her character's wardrobe on more than one occasion. So her wardrobe was obviously an issue to her. She obviously felt comfortable saying things about how other actors or actresses on set appeared, and yet she's saying she was sexually harassed because of that. Okay. Sexiness was indisputably used at times to describe a film devoted to adult themes, not invoked to pit one gender against another. Lively also complains that Baldoni improvised physical intimacy. Lively adduces no evidence to suggest he did this to offend her based on her gender. Baldoni was not targeting Lively as a woman. He was in character, filming a scene in which, as Lively puts it, his character and Lively's were redacted. Such conduct would not be acceptable in a typical office setting, but in the context of two professional actors making a romantic, sexually charged movie, it cannot constitute discrimination. And this is where the law, this is so important. Such conduct would not be acceptable in a typical office setting. Right. So we all know that the things that happened on that set in this romance movie that they were making about sex, romance, and domestic violence, they would not be acceptable in an office setting. But we have to understand, like, that's not the setting that they were in. And it makes it more ridiculous that she's exploiting these laws, exploiting these rules that are set out to protect women in these office spaces that most of us face every day, when we have to deal with male bosses or male employers, male coworkers. Like, it's meant to protect the people who have to deal with that, who face, sexually charged issues in the workplace, or, discriminating issues in the workplace. And she's exploiting that to try to say that this was some kind of violation of the law, when the truth is they were working on a movie where the characters are fucking each other. So yeah, there was some sex stuff going on there. And she was offered a chance to speak with an intimacy coordinator, a female intimacy coordinator, and refused. So, all right. Lively's own declaration describes other kissing scenes in the film as vital to conveying the redacted. And of course, now we know why Blake's own declaration is redacted. Her complaint that Baldoni added intimate scenes fails for the same reason. Lively does not dispute that she too revised the script to increase and then it's going to be something about intimacy. So she also revised the script. Any gendered animus is further undermined by undisputed facts that Lively was invited to discuss her views about the intimate scenes with female intimacy coordinator before filming and proposed revisions. Lively's effort to evade this conclusion by characterizing the film's birth scene as unscripted nudity is absurd. She claims she was unexpectedly required to imply nudity under a hospital gown and prosthetic belly, but Lively, a mother of 4, must have known people generally don't wear pants to give birth. Nor were comments Baldoni supposedly made to Lively about his personal experiences gendered. It is undisputed any such comments were substantially similar to statements Baldoni has made in his talks and books aimed primarily at male audiences. And this is an important point right here. So Blake Lively and Ryan Reynolds both, before Ryan was dismissed from the lawsuit, both tried to point out that he acts as like a male feminist and has said all these things about the Me Too movement, blah, blah, blah. But his primary audience, if you actually listen to the Man Enough podcast, if you actually read Justin Baldoni's books, which I have, because I'm not going to go into something like this not paying attention to the man that in question and like say a woman is lying. I'm not going to do that without paying some attention and like doing a little bit of research on the background, right? And you can tell that the Man Enough podcasts and the books are aimed at men. It's aimed at disestablishing, I guess is the word, I don't know, dismantling this idea of toxic masculinity. It's aimed at trying to embrace masculinity in a way that's healthy, where they can express their emotions and their feelings, and it's safer for women, and they don't dismiss women, they listen to women, they don't, automatically talk over them and shit like that. Like, that's the kind of thing that Justin and Jamie and whoever was involved in Man Enough, even Sam, his father, was on an episode of Man Enough, which was a beautiful episode. I would encourage anyone to watch that. His wife, Emily, was on an episode, which was also amazing. If you watch these things, if you listen to these things, you can see it's all about helping men kind of overcome these expectations of masculinity that is toxic, which Justin hates that term, and embracing masculinity in a way that is equal to the women in their lives and is, equally involving and respecting the women in their lives. And so Lively and Reynolds pointed out all these things in Justin's speeches or his books and tried to make it sound like you said you were supposed to listen to women and you didn't. And that's so fucked up. Because again, this is a disservice to everyday women in America who face these awful things in the workplace and just in general, who don't have private security, who don't have the opportunity to say these creepy things to men and then be like, well, he responded, so it's sexist. You know what I mean? Like, it's so against what women in this country actually need and what men in this country actually need. It makes no fucking sense. If you really, really read and listen to the things that they're citing here, and then you look at the little excerpts that they're giving and the things that they say, it's so destructive to regular America. It's so destructive to like regular people every day who suffer through the kind of toxic social norms that we've had that we're trying to break down. But they're like, then she's like, well, ignore that. Just listen to this part. And, well, he's bad, so we shouldn't listen to anything he has to say. Or he said that in his past, he didn't listen to women. So now we know that he is sexist. No, like if somebody's open and vulnerable and telling you like, this is what I learned from the people around me, my peers and stuff when I was growing up. But then I came to realize that stuff isn't true. That stuff is toxic. That stuff needs to change. And this is what I did to change those behaviors. Don't then take the past and ignore the present or anything they did to work on that and to change things and pretend that they're just this terrible person. Because that just discourages people from in the future coming forward and saying, hey, this was wrong. I need to do better. So hopefully my little tangent there made sense. Give me 1 second. I need a sip of water. But yeah, the whole the thing with Lively and Reynolds and quoting his books and his talks, it's sick. It's sick because it's trying to take away any benefit that it has to larger society. And it's trying to pretend that there was no growth or positive outcome from that and just hurt him with it. And if you're a celebrity or like a, somewhat known actor like Justin, you're then going to be discouraged from doing that in the future. You're going to be discouraged from self-reflecting and doing things to make the world a better place because you think, well, if I talk about this honestly, if I'm open about this, somebody might come back and use my past to try to hurt me in the future. The way that Blake and Ryan are doing right now. So it's fucked up. Anyways. Okay. And here we're going to talking about Heath a little bit more. 1 sec. I'm about to sneeze. Okay. My bad. Okay. Nor did the 2 alleged incidents involving Heath provide any evidence of gender discriminatory animus. Lively cannot dispute that 3 witnesses testified Baldoni asked Heath to show Lively the birth video for non-gender-based reasons. Okay, so that's important there. 3 witnesses testified to that. Following discussions about the birth scene in the film. Okay. Indeed, she admits Baldoni contemporaneously told her, redacted, after Lively objected, no one persisted in showing her the video. It is undisputed that Heath also showed the video to Baldoni and Baldoni, a male participant in the film. So you can't argue that was like a gendered thing. He didn't just show it to women. And then as soon as she said like, no, I don't want to see that right now. He was like, okay, sorry, my bad. But is also, mentioned in their responses or their complaints that she talked to Justin before viewing that video. And he said, I want you to look at this because I have this vision of this scene. Are you willing to look at this? She said, yes. And then Jamie brought it to her. So, all right. Similarly, Lively admits Heath entered her trailer once, not for any gender-related purpose, but to discuss, and that's redacted, with her permission. Lively asked Heath to turn away from her, and he undisputably did. She claims that at some point he glanced at her anyways, but doesn't dispute later assuring him, I'm not saying you were trying to cop a look. She cites no evidence supporting her claim that she raised the incident with Heath, nor is there any evidence she raised it during the call with the Sony executive a few days later when she redacted about the production. And while harassing conduct need not be motivated by sexual desire, Lively omits that the very sentence she cites for the proposition underscores the conduct that must be motivated by gender, or underscores that the conduct must be motivated by gender. Okay. She cannot make that showing here. Lively defends her reliance on limited, sporadic, one-off instances of alleged misconduct by citing one case in which a single incident sufficed. In reaching that conclusion, the court was clear that isolated incidents must be extremely serious to give rise to an actionable claim. Unlike here, the incident in Bailey, the case she cited, involved an unambiguous racial epithet. Well, if you want to talk about racial issues, Blake Lively is the one that has them. But yeah. It involved the N-word. So I think we're a little off the mark here. Beyond Heath's conduct, Lively does not even claim anything she personally experienced was sufficiently severe or pervasive to prove harassment. She largely ignores significant authority confirming her allegations are too mild. She dodges the undisputed critical fact that any alleged harassment ceased once she raised concerns, no issues arose, and no incident recurred throughout the remainder of the filming. So even though they disagree that what happened was harassment, they disagree with her characterization of things, when she raised these issues, they were extremely careful that nothing of that nature that she complained about happened on set. So that is not a severe or pervasive issue. And that was not just defendant's view. It is undisputed that, and unfortunately this is redacted, and it's about Alex Sachs. So Sachs testifying that Sat was redacted. How could the conduct be severe or pervasive if it vanished once the issue was raised? So much so that Lively, advised by counsel, concluded no formal HR process was warranted. Even the authorities Lively claims supported a relaxed standard require proof of severe or pervasive conduct for a hostile work environment claim. Good. Lively relies repeatedly on, and I think we'll probably skip this part. Yeah. Lively tries to bolster her claim by invoking the alleged experience of other women, and we know that includes Jenny, Alex, whatever. There was no evidence Lively knew about most of the alleged events prior to litigation, if they even occurred. So she didn't even know what happened. She sued Justin for sexual harassment, and then later talked to these other women and was like, what can you tell me that would help me out here? And this is just a scenario that I'm, based on her behavior and my experience with Blake and her lawyers myself, this is what I think happened. She sued Justin. She went to the New York Times, then she sued Justin and everyone else. And then she said to all the women that she failed to cite in her initial article or lawsuit, when she didn't have any actual evidence, once it was disputed, and said, what can you tell me about your experience with these guys? Did you ever disagree with them? Did they ever do anything that upset you? Whatever. What can I use here? Sounds like it happened after the lawsuit was filed. Okay. Several of these alleged events are supported only by rank hearsay or otherwise inadmissible evidence. Such unsupported claims must not be considered. So we're at the end of this paragraph, so I just want to point out here, what motivation would Blake Lively have had if, as she said in her, recent response, multiple women were getting this backlash in the press? What motivation would she have had not to then bring up what these women said happened on the set, other than she didn't know and she was later digging for information from these guys? Like, she would have brought this up, the yelling at the female producer, because make no mistake, if you file a lawsuit like this, there's a chance it's going to go to trial. So you're not doing this without knowing that people are going to have to stand up or go up on the stand and talk about what happened that you're alleging. What motivation did she have for not telling people when she was working with the New York Times before the lawsuit was filed, that he had allegedly yelled at women on set, or that he had allegedly, upset Christy Hall or Jenny Slade or, whoever? What motivation would she have had not to raise these things at that point? Because she knew when she decided to go to the New York Times, she knew she was filing this lawsuit. That's why she did the CRD complaint. She knew that she had to. She knew when she filed the lawsuit that these people were going to have to come forward and talk about these things, and that she could not protect them from public whatever. And she had the perfect opportunity in the beginning of this, with the New York Times on her side and nobody on Wayfair's side at all, to say whatever the fuck she wanted. And yet she never mentioned any of these things about the yelling, about the not giving women authority over things that they felt like they were entitled to, about the giving Jenny Slate money for a new apartment when she felt unsafe in her old one with her new child. Like, you didn't think any of these things were pertinent before? And now all of a sudden they're coming up? Not that they support her claims at all, but because I got to tell you guys, from a random, like, everyday American's perspective, who's not a rich actress on these sets, I got to tell you, your boss giving you an extra allowance for a new place to live because he wants you and your child to be safe, not sexual harassment. Don't tell anyone I said that. All right? Anyways, there was really no reason for her not to bring this stuff before, and now she's flailing, and now she's trying anything she can, but it just doesn't add up. Hey, Rob, what's going on? All right. Moreover, the conduct she discusses adds little weight to her claims. Like Lively, co-star Jenny Slate refers to a single instance in which Baldoni referred to her wardrobe, which included black leather pants, as sexy, a term which, as noted, was widely used on set, including by Lively herself. So if you guys are walking around saying sexy, 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 I want to look sexy, and the director's like, oh, that outfit looks sexy, sue him for hundreds of millions of dollars? Go fuck yourself. A one-off remark may be unwelcome, but it is not so severe or pervasive as to give rise to a claim. It is undisputed that Baldoni acknowledged Slate's concerns. So the second they said, we don't want you saying that, only we can say that on set, even though that's unreasonable and kind of stupid in my opinion, they still said, okay, it won't happen again. And then she's like, you owe me like $200 million or whatever the fuck. All right. Lively also claims Baldoni yelled at a female producer, Alex Sachs. Yelling without more is not evidence of gender bias. Even Sachs resists such an interpretation, noting that Baldoni treated men similarly. So she writes here that defendants have a way of making women and some men feel like shit. So even in her account of things, which is largely disputed, she admits it wasn't a gender thing. Okay. Lively's references to verbal abuse supposedly experienced by another director, that's Claire Ayub, on another set of a different film, have nothing to do with the work environment at issue in this case. In any event, the alleged verbal abuse is only vaguely described, with no suggestion it was either sexual or gender-based. And we know Claire Ayub made no complaints about Justin Baldoni in that call with Steve Sarowitz, which is their only evidence of that. He disputes that he was ever banned from her set. She says now, after she's had contact with Blake, that he was. There's no proof of that, ever. He was never banned from her set. She said after the It Ends With Us stuff happened, which was a long time later, she didn't want him involved in the marketing because of the controversy. So Claire Ayub, in my opinion, is still an ungrateful bitch. I'm not sorry for saying that. What she did to Steve was inappropriate. The way that she didn't bring up Justin at all, especially when Steve was singing Justin's praises. She didn't mention anything about this alleged issue she had with him on set. Didn't say a word. And then Steve apparently would not have known that Justin was banned from set, and she didn't think to mention it. It's all bullshit. All bullshit. Likewise, the claim that author Colleen Hoover was not involved in the script and did not receive dailies, she's not entitled to that shit, has no evident connection to Hoover's gender or the on-set environment. Finally, Lively criticizes Baldoni, and then there's lots of redactions there. And they say there's no evidence it was gender-based. Okay. Because, as now is undisputed, all the issues Lively raised were resolved. She cannot show that the conditions of her employment changed. This is yet another reason to dismiss her claims. She argues even though she voiced no objections during the second phase of filming or thereafter, defendants' huffy and defensive reactions to Lively's behavior were themselves harassment. Well, if I had someone who was trying to hold my film hostage after I did nothing wrong, after they'd been my friend for years or months before, acting like they were totally fine with my way of approaching things, I would probably be a little huffy. Yeah. I'd probably be a little huffy. I mean, maybe it's a matter of personal opinion, but yeah. All right. Okay. But the two occasions in which Lively claims had occurred were both during the first phase. Okay. So even when she said they were being huffy in response to her weird demands, it was still during the first phase. And immediately when she brought it up, that alleged behavior ceased. They may not have agreed with her accusations, but they were extra careful to make sure it didn't happen. So, right. Lively cannot prove any actionable retaliation. Perhaps aware of the shortcomings of her argument, Lively insists very little evidence is required. What she has is not enough to save her retaliation or aiding and abetting claims. Lively claims she has made out a prima facie case, fails on multiple grounds, and even if she has, defendants have presented a clear, non-pretextual justification for their publicity efforts, which were a reaction to a media firestorm and not to any complaint by Lively months before. So she has no way of proving that their media stuff was in any way related to what happened months prior to that. They started to be defensive before the premiere, during and after the premiere, when she freaked the fuck out and was, ready to scorch earth on him. And, the publicists, Stephanie, who basically worked for Blake at that point, and Leslie were doing stuff in the press that they shouldn't have been doing. And so she's saying that all this stuff was retaliation, but all what they did happened well after that and only in response to her moves in the press. So also nothing they said was untrue. All right. Lively did not experience any adverse employment action. It is now beyond dispute that no material aspect of Lively's employment changed for the worse. Her compensation did not decrease. Her role was not diminished. That alone is enough to defeat her FEHA claims. Lively tries to evade the point by expanding her supposed employment to include post-filming activity, as well as her campaign to get a PGA mark. But Lively was not hired as an editor, director, or producer. That she had any role in post-filming activity is proof that her responsibilities expanded, not contracted. So she was never punished or, affected negatively at all by her claims. She was given more power, more control, more of what she wanted. In any event, it is undisputed that Lively did get the opportunities and references she sought, including defendants' endorsement of her PGA mark. She described her accomplishments, and it's redacted, and not as any setback. Okay. Lively's complaints that she was made to feel guilty and was criticized to Hoover and others are minor or relatively trivial adverse actions that, from an objective perspective, are reasonably likely to do no more than anger or upset an employee and are not actionable. And then they cite here that actions that do no more than subjectively upset the employee or are not to her liking are not adverse employment actions. And that's true and reasonable because lots of people get upset by lots of different things, right? So if we just sued everybody for hundreds of millions of dollars for saying something that, we didn't like, holy shit, that would be crazy. And once again, another abuse or misuse of the court system by people who have way too much money and power already. So any such conduct had no material effect. The record is replete with evidence that after the May 6th dinner, about which Lively complains, Hoover worked closely with Lively. Okay. In lieu of any material harm, Lively relies on the CRA to argue that mere changes in attitude or sarcasm could be enough. Oh my gosh, I did something terrible to them and I held them hostage and they were sarcastic to me. I'm suing. Oh, shit. In lieu of any material harm, Lively relies on the sarcasm and change in attitude. Okay. Yet precisely because there is no material harm, no damages can arise from any alleged contractual breach, even assuming the CRA was a binding agreement, which it was not. Okay. Defendants' publicity efforts were reasonable defensive measures that are not actionable as retaliation. Lively cannot meaningfully dispute that defendants' publicity efforts took place outside the workplace in the arena of public opinion, which is what we're doing right now, right? Hey, Bruce, how's it going? I'm going to sue you. Who are you suing, Gilda? All right. Undisputed facts show Lively chose that arena and exercised immense power within it. It was Lively who unfollowed Baldoni, tantalizing social media sleuths. So her actions led to people from the public looking into why did she unfollow Justin Baldoni? Why did Jenny unfollow Justin Baldoni? Why did Brandon, So it was her actions that caused public scrutiny, public interest. While Lively redacted causing a media furor just days after the premiere, and it's redacted, unfortunately. So Lively's opposition fails to identify a single factually false statement defendant shared or promoted in response to this onslaught. Okay. She claims multiple incidents placed Lively in a false light, but fails to say which ones or how. And the ones that she has pointed out, like Shasti Flaw's video, didn't have anything to do with Wayfair. It turns out if you are a dick to people, some of them hold a 50 cent like grudge, and they might come back and put that out later in a way that hurts you. in a way that you earned, in my opinion. The way she treated Shasti was disgusting. Shasti was graceful and moved on and didn't put it out there for the universe to see. And then when Blake decided to treat other people with the same disgusting behavior, Shasti on her own said, no, it's true, Blake is kind of fucked. And I'm not speaking for Shasti, I'm paraphrasing what happened, right? These are not her words. So she said, that's fucked up. So then she puts out this video and shows, no, Blake Lively really is just kind of like this, you know? So Blake Lively even went so far as to tell the New York Times to put Shasti as a target in her article. How fucked up is that? And how unself-aware is that she would go that far to drag her, thinking that it must be Justin and his team that caused this, when actually Blake has just been a bitch to a whole lot of people. You know? So, all right. She complains defendants exposed her to criticism for past conduct, but does not dispute those criticisms were already in the public domain before any publicity by defendants. Lively faults defendants for supposedly contending she weaponized feminism and took the movie over, but it is undisputed that Lively claimed to have, and then there's lots of redactions here, clearly invoking a feminist theme. Lively asserts she was unfairly criticized for shifting the film's marketing strategy away from domestic violence. Yet it is undisputed that the film was always intended to raise awareness about domestic violence, and that Lively, and it's redacted, in claiming Heath admitted her marketing was redacted, Lively misrepresents. In the very document she cites, Heath expressed concern to Sony about how many people are pointing out that the DV is being glossed over, and encouraged everyone to be more deliberate in embracing the DV aspect. Regardless, it is undisputed that Lively was criticized not simply for de-emphasizing domestic violence. Oh no, I'm going to sneeze again. Hang on. My bad, guys. Not simply for de-emphasizing domestic violence, but for simultaneously promoting her other projects and those of her husband as well. The record is clear such criticisms appeared in the press, independent of any effort by defendants. Lively cannot prove causation. Lively engaged in no protected activities after her protections demands. She tries to shrink the temporal gap by stretching out her claimed protected activities. That doesn't work, because Lively has never before claimed any of the additional events she now relies upon, such as, unfortunately it's redacted, or refusing to promote the film with Baldoni as activity intended to oppose discrimination, and there was no evidence any defendant understood them as such. So these redactions, most of them are going to be unredacted, or like the unsealed versions will come out, but it's going to be a little bit longer. I think the parties jointly tried to ask the judge for an extended time to say what should or shouldn't remain sealed. I'll ask Cassidy because she's really good on the deadlines, but I think it's going to be... Oh, Stuart, what's going on, man? So this is their response to Blake's opposition to their motion for summary judgment, but it's good to see you, dude. I was thinking about you. Me and Omar have been talking about you. We're like, where did they go? But thanks for stopping in. I like your picture, by the way. You guys look like you're in a helicopter. All right. Anyways. So, yeah. So they're saying, there's no evidence that Wayfair understood that there was any sort of discrimination for them to fight against. But she's claiming there was. This is what my understanding here. Okay. So she never claimed there was any sort of real discrimination in refusing, and that's why she refused to promote. But there was no evidence that that's what she was saying for them to oppose, I guess. That's my understanding. Elsewhere, Lively describes redacted as immaterial, and her cited evidence doesn't refer to redacted. Okay. She now relies upon... Oh, I don't know what that says because it's redacted. An action cannot constitute protected activity where there is no evidence the employer knew that the employee's opposition was based upon a reasonable belief the employer was engaging in discrimination. So the issue of discrimination was never really raised at the time, so they can't really respond to that, Okay. And even assuming such conduct could constitute protected activity, it is undisputed defendants respected Lively's request. Baldoni did not insist on promoting the film with her. Okay, so he didn't say, like, I must promote this film with Blake. We need to go act all coupley and shit. You know what I mean? So, yeah. All right. Okay. Lively lacks direct evidence of retaliatory animus. Lively next asserts the temporal gap between her objections and the publicity campaign doesn't matter because she can show a direct causal link. But conspicuously lacking from the record is a single piece of evidence in which defendants say they are initiating a publicity campaign to get back at her for raising objections on set. So, yeah. That is, so I agree with what they're saying. I think that's like a hard thing to prove. So in a alternate universe where we're talking about two different people that I don't know anything about, I could see that being just like a hard thing to prove. So that's something that I feel like you have to have like facts presented to a jury or something to decide. I don't know. That's just my thought. But I'm not a lawyer. You guys know that. So instead, she relies on messages in which defendants express concerns about her possible prospective activity and seek to prepare for the fallout. Those cannot prove a retaliatory motive, and it is undisputed that defendants' conduct consistently resulted in Lively's gaining more power over the production, not less. Undisputed evidence proves defendants' non-retaliatory motives. Lively argues no admissible evidence shows defendants had a legitimate non-discriminatory motivation. She is wrong. Okay. Undisputed facts show that when defendants decided to engage a crisis PR team, they did so to protect their own reputations and that of the film against an anticipated onslaught of negative publicity, not to retaliate. Okay. Indeed, Lively admits defendants first met with TAG only on July 25th, after negative publicity had already begun. Lively lacks evidence to show, as she must, that her purportedly protected activity was the but-for cause of defendants' conduct. She cannot possibly meet that burden on this record. Nor can Lively credibly argue that defendants welcome the media fracas. Is that the word, fracas? I don't know that word. I'm going to be honest. I don't know the word. As a pretext to attack her for her objections. Okay. Rather, undisputed evidence, including materials Lively cites, shows that defendants were terrified and doing everything they could to avoid a confrontation. So this is where I started to kind of highlight stuff so I could skip over some of it, but post-litigation conduct cannot save Lively's claim. So she claims the smear campaign is ongoing, that Brian Friedman's statements were a part of it, etc. So Lively leans heavily on actions defendants and their counsel supposedly took after she filed her CRD complaint. But if Lively did not suffer any actionable retaliation before commencing litigation, she should not be able to create a claim based on post-litigation conduct. I mean, that makes sense. I don't know the law necessarily around that, but I think that makes sense from a logical standpoint, from a layperson standpoint. Any such conduct by defendants would be a response to the litigation she commenced, not a response to any workplace complaint about harassment from many months before. Okay. Lively was an independent contractor, not an employee. So we're going to get into that stuff about the ALA and all that, which is where a lot of the attorneys who cover this case say it has, industry-wide implications and how it might affect people who act in general, who sign on to these films in general. So people sign on with an actor loan-out agreement as an independent contractor, which has some implications for if she were to be considered an employee after everything that we've seen and her contracts that were never actually signed. It would have implications for other actors who are signed on with an ALA for other movies. And so the judge we'll have to take that into account. Like, hey, this doesn't just affect the people in this case. It's going to affect how actors who have these contracts are viewed in the future. And there are benefits and drawbacks to signing with an ALA versus being a contracted employee. And actors with the ALA would then be at risk of being viewed in a lawsuit as somebody who is or is not an independent contractor based on Blake Lively's case. So. Okay, and I don't want to say too much about that because I'm obviously not an attorney, but Not Actually Golden talks about that a little bit. Let's see. Lively attempts to paint herself as a mere employee. In doing so, she ignores her own extensive admissions. She also ignores the highly bespoke contracts she negotiated, including an agreement that the production's location be moved closer to her own home, rights over many aspects of production, and a rider, the CRA, insisting her own unilaterally imposed terms as a condition for going forward. If, as she argues, control is the determinative factor in determining whether a traditional employer-employee relationship exists, it is difficult to imagine anyone having more control. Okay. Lively's opposition also points to the actor loan-out agreement, but the terms of that agreement were never fully negotiated and the agreement was never signed. The application of California's business of business exception similarly cannot be denied, whereas here, the work was performed pursuant to a business-to-business transaction between It Ends With Us movie, on the one hand, and Lively's loan-out entity, Blakel Incorporated, on the other. Okay. Far from a typical employee, Lively independently contracted through her own private business entity and exercised tremendous control while maintaining the right to work on other projects and for other businesses. If she is not an independent contractor, then there is no such thing as an independent contractor. All right. Lively's contract claims fail. She's abandoned her breach claims against Wayfair. Lively makes no effort to defend her alter ego theory breach of contract claims against Wayfair, which, unlike It Ends With Us movie, was not a party to the ALA and CRA. The claims against Wayfair must therefore be dismissed. Okay. Judicial estoppel does not apply. Okay. Contrary to Lively's argument, the entity defendants are not judicially estopped from arguing that the ALA is not binding. Okay. So judicial estoppel from my non-lawyer standpoint means if the Wayfair parties had successfully argued one thing. So if they successfully argued that the ALA was binding, then the judge could stop them from now making the argument that the ALA is not binding. But that's not necessarily what happened. They only had one claim in their countersuit related to the ALA, and this is just my memory and my understanding. And the judge dismissed that, and they had an opportunity. They could have amended, and they could have tried to move forward with that claim, but they opted not to. So Lively is saying that because the Wayfair parties may have made some sort of argument that the ALA, was binding, they now cannot make the argument that it was not binding. But the thing is, the court never recognized or gave any sort of credence to their argument that the ALA was binding. So if they said the ALA is binding in their case, and the judge agreed with that, and he, let them go on with that claim, and then they tried to say the ALA is not binding in this case, then they can't do both, is kind of what that's saying to my understanding. And I'm not a lawyer, so double check that with your lawyer friends. But to the best of my knowledge, a judicial estoppel is like saying, we're not going to let you to make this argument when you basically made the other argument and we agreed with it in this part. So, yeah. Okay. Give me 1 second to take a sip. Okay. First, the court has never previously adopted any position advanced by defendants with respect to the ALA. And in order of dismissal, it rejected defendants' only arguably related claim. Okay. Second, defendants' prior pleading was not inconsistent with their current position. It, too, pointed out the ALA had never been signed. Third, the entity defendants gained no unfair advantage based on the alleged inconsistency. In dismissing the prior claim, this court noted allegations that the ALA had never been signed, and defendants chose not to replead the claim, though leave was granted. Okay. Lively falsely claims defendants confirmed in writing that Wayfair was waiving execution. Okay. That did not happen. The cited evidence shows Heath told Lively's reps, "We have withdrawn our request for your client to sign her agreement in order to extend the time with the edit." Heath gave Lively more time to edit the film without signing the draft ALA a condition of the concession. Heath was clear the contract negotiations remained open. He wrote, "As for the future resolution of the contract, we will stand by in hopes that we come to a conclusion soon." Lively also falsely claims It Ends With Us movie, did not dispute the execution condition had been waived. The opposite is true. When Lively tried to strike the execution condition and claim it had been redacted, It Ends With Us movie rejected the edit. So there's a lot of back and forth here about the contract. Lively's own evidence confirms that because the ALA was not finalized when principal photography commenced, her lawyer insisted that until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the negotiated deal memo. In other words, the parties would rely upon the offer letter. Moreover, both New York and California law require unequivocal expression of intent to waive, especially where, as here, the contract expressly bars modifications not signed and in writing. Okay. For similar reasons, the ALA was never binding. As noted above, Lively does not meaningfully grapple with undisputed evidence showing the parties did not intend to be bound absent a fully executed writing. Okay. And this is, like I said, a lot we're going to skim over, guys. Let's see. Lively's argument that the ALA was performed also fails because Lively cannot meaningfully dispute that performance occurred under the offer letter, which set forth the key terms between the parties. Lively's argument that execution of the CRA suggests the parties understood the ALA was already a binding agreement is flatly contradicted by the record. If the CRA manifested the parties' understanding that the ALA was a done deal, there would have been no need for roughly 6 more months of negotiations, nor any reason for Lively to decline to sign. Okay. Lively also ignores that even if the ALA were a valid agreement, or defendants are stopped from arguing otherwise, the execution condition precedent would still prevent her from enforcing the ALA, as well as the CRA, which was incorporated into the ALA. The draft ALA made execution a non-mutual condition precedent to It Ends With Us movie's obligations, not a condition precedent to contract formation. The CRA is not binding or enforceable against the entity defendants. Lively's defense of the CRA's enforceability rests almost entirely on her contention that the ALA was binding and enforceable, and therefore fails for the same reasons. Okay. Lively's observation that contract modifications do not require new consideration is beside the point, because defendants' consideration argument only goes to whether the CRA is enforceable as an independent agreement. Lively's contract claims fail even if the ALA and or CRA are enforceable. Okay. Lively does not dispute that she did not satisfy the notice and cure provision in the ALA before suing. She claims defendants waived the notice and cure by failing to include it as an affirmative defense. But courts applying California law have held compliance with contractual notice and cure provisions must be pleaded by the plaintiff and need not be asserted as an affirmative defense. Lively's contention that she satisfied the provision by amending outside the cure period after her initial complaint provided written notice is absurd. A party cannot evade clear notice and cure requirements by simply filing a lawsuit and then amending once the cure period has run. Yeah. Lively's damages are barred. They have an argument here. Lively does not dispute that she can't seek duplicative recovery for the same injury by asserting overlapping tort and contract claims. Since her claimed contract damages, oh, wow, I accidentally moved the page there, didn't I? Yep. Hold on. I hit a button, guys. Okay. Nope. I lost myself. Help. Let me move back up here. Okay. So we talked about the notice and cure. Courts applying California law have held compliance with contractual notice and cure provisions must be pleaded by the plaintiff. Okay. Lively's contention that she satisfied the provision by amending outside the cure period is absurd. A party cannot evade clear notice and cure requirements. Let's see. Lively does not dispute that she can't seek duplicative recovery for the same injury by asserting overlapping tort and contract claims. Since her claimed contract damages entirely mirror her alleged tort damages, her contract claims fail. So I don't want to go through that too much. Let's see. Defamation and false light claims fail. Lively concedes, as she must, that her defamation claim is based entirely on defense counsel's denials of Lively's allegations, asserted after litigation commenced in the context of discussion of the litigation. That concession is fatal to her claim. She cannot establish falsity or malice. Contrary to Lively's assertion, defendants have made a strong showing that no actionable harassment or retaliation occurred as discussed. Accordingly, statements denying Lively's claims are true, or at least substantially true, which is all that is required to defeat a defamation claim. Lively does not meaningfully dispute that what constitutes retaliation, harassment, or a smear campaign is imprecise and subjective, such that a denial of such conduct constitutes unactionable opinion. Okay. Lively also fails to muster evidence sufficient to prove actual malice with convincing clarity, as she concedes is her burden. Lively reiterates her argument that defendants must have acted with malice because they knew that Lively complained of supposed harassment on set. Lively does not respond, however, to the obvious point that knowledge of a complaint is not knowledge that harassment had in fact occurred. So they know she complained about it, but that does not mean they know that anything improper actually happened. All right. Lively argues for the first time that the statements were false and published with malice because they assert Lively lied about harassment to gain control of the film's marketing, which is definitely something that I have said with certainty, but I don't know that this counts for the defendants. This novel theory appears nowhere in Lively's second amended complaint, and a plaintiff may not, in an opposing motion for summary judgment, rely on theories not set forth in the complaint. In any event, none of the statements specifically says Lively fabricated claims to take over the film's marketing. No, I say that because that's what I think is the truth, but nobody suggested that I do so for money. Lively fails to rebut that the allegedly defamatory statements are absolutely privileged. Okay. Lively first suggests the fair report privilege does not apply because an ordinary reader or viewer would not perceive defense counsel statements as reporting on the proceeding. What are you talking about? But a fair reading in the context of the publication as a whole shows the statements were clearly comments on the litigation and mirrored defendants' positions throughout the litigation. Yeah, I mean, that seems pretty basic. So I'm not going to go through this too much because that is a well-established, in the court of public opinion at least, a well-established fact. So in any event, it is not necessary that the court filing, the court, or the jurisdiction be specifically identified in the article for the fair report privilege to apply. So she's like saying, Brian Friedman didn't say specifically that this was an allegation in the article or in the filing or whatever. So that means, it doesn't apply for privilege, but it's not necessarily true. And a statement need not reproduce a court filing or proceed verbatim for the privilege to apply. And a lot of this stuff is like, she's saying that the Wayfarer parties are guilty of something for the same reasons that the Wayfarer parties accuse the New York Times of being guilty of something. But the New York Times, which she doesn't disagree with the ruling, the New York Times was ruled to not be, liable or have done anything wrong because of the fair report privilege and the litigation privilege, where she didn't have a problem with that, right? Because she went to the New York Times. But now she has a problem with these guys using the same defense, which is interesting. Okay, let's see. Lively's false light claim fails. Her choice of law argument assumes the California choice of law provision and the unexecuted ALA applies, but for the reasons explained, the ALA is not binding or enforceable. Lively's argument fails because the ALA does not bind the defendants who were never parties to any ALA draft. She attempts to end run this rule by calling the defendants closely related parties of It Ends With Us movie, but her own cases undermine the argument. And I'm not going to get into the case law here because I'm not an attorney, guys, so you know that. Lively separately argues for application of California law, pointing to what she describes as California conduct. And this is where we get into the part where she's again sexualizing birth, which is just amazing. This argument is blind to choice of law principles that favor application of New York law. Okay. Lively's mid-production conversation with defendants about their conduct, their alleged on-the-set behavior, and the premiere of the film, attended by Lively and Baldoni. She's saying that the balance of conduct indisputably occurred in these situations in New York or New Jersey. She claims defendants executed a communication strategy from California, but overlooks detailed allegations in her own pleading that placed defendants and herself in New York when the strategy was purportedly hatched. Okay. In short, the most significant relationship factors clearly support application of New York law. Lively would fare no better even if California law applied. Indisputably a New York resident, she asked the court to ignore the impressive body of authority that limits standing to California residents. Lively concedes conspiracy liability cannot arise from contract claims and she fails to meaningfully oppose defendants' arguments that New York conspiracy liability cannot attach to California FEHA and federal Title VII claims. Her conspiracy claims are entirely duplicative of her underlying tort claims and must be dismissed for that reason alone. Okay, they're saying here Sarowitz must be dismissed. Lively strains to implicate Sarowitz despite his undisputedly peripheral role, she claims, but without evidence that he was on set during the birthing scene. Lively's declaration states only that Sarowitz was present on the set that day, without specifying any scene or shoot he attended. So it's like she looked at the visitor log or something for that day, and it could have been like hours after they shot that scene, and she was like, oh my God, he was here looking at my vagina, even though she had shorts on. Ridiculous. Okay. Let's see. So she also claims Sarowitz is liable because he made a suggestion about flipping the narrative when the truth is, and this was about the feminist, the feminist perspective and like the Ryan taking over the film, not taking over the film, but the script, Ryan and Blake taking over the film. But she admits that his suggestion brought to light the fact that Ryan rewrote portions of the originally female script. So like Blake and Ryan are trying to suggest that the Wayfarer parties were not as feminist as they say, yet Blake and Ryan were the ones who had Ryan rewrite some of the female written script. But yeah. Lively also fails to identify any evidence to support her claim that Sarowitz threatened to ruin her family. Undisputed evidence shows Sarowitz never made such a threat. Lively fails to oppose defendants' damages arguments. Okay. Her damages arguments confuse the issues. She claims standing to pursue damages to her own reputation, but falsely equates personal reputational harm with the speculative lost profits purportedly sustained by separate businesses. She has no standing to seek such damages, which are in any case too speculative. All right. And then they ask that the court obviously grant the summary judgment motion. Let me find that word that she hated so much. Okay. She claims, but without evidence, that he was on set during the birthing scene. Okay, I think it birthed is the word I'm looking for. What is the one they were freaking out about? Let me just look at birth. How about that? Birth. Unscripted nudity. Lively's effort to evade this conclusion by characterizing the film's birth scene as unscripted nudity is absurd. All right, we went over that. Yeah. Unexpectedly required to imply nudity. And if you guys were here on Friday night, I did some implied nudity in the stream that night. So, implied nudity means jack shit. Let's see. Birth video, birth scene. I don't know where. It might be in the M job, actually. Hang on. Oh, it is. Okay. So this is the reply to the opposition to the motion for judgment on the pleadings, which is the other document. And it says, it's strange credulity to argue that using the term birthing as a substitute for creating was sexual or harassing in nature. So, yeah. Let me pull these up real quick. Marilyn CH, thank you for the $5. I hope Judge Lyman rules on the law because none of this would matter. Also, thank you for the 2. Thank you for your time. Thank you. I appreciate that. And also for the 5, employers will hire people as independent so they don't have to abide by employer laws. These rules are supposed to protect them, not Blake. There's benefits for both sides, I think, but she's trying to pretend that they don't apply, which is ridiculous. And thank you again for the 5. If you've never been wrongly classified as an independent contractor, you might not understand why these rules exist. Lottie of Wales, thank you for the $10 super sticker. I appreciate you. Let's see. We got here. We got 15 pages of this. I think what I'm going to do is, well, we can keep going, I guess. There's not too, this one is not very long. So I guess we could go through this together if you guys want. I just know it's been already kind of a long stream. It's been almost an hour and a half already. And it's 10:45. Let's see. What I'll do is, how about I'll do this one tomorrow morning. The opposition to the MJOP, the reply to that. Since we've already spent an hour and a half on the other one. And I'm not trying to spend 4 more hours and like have everyone be like, oh my God, it's too long again. So we'll do that tomorrow morning. Probably around 10 a.m. or something Eastern. Because I got to get some sleep before work tomorrow. And also, I don't want this to drag on too long because I know people had lots of complaints about that. So, all right. Thanks, everybody. I will see you guys in the morning. If you can't make the live, it'll always be there for a response afterwards. Don't forget to like this stream for me if you can. And I will see you all soon. Appreciate it. I know it was like an hour and a half still, but the shortest I could. So, all right. Bye, guys.